started, and now let me start the main recording. Okay, so now everything's recording all the way across the board. Okay, so the first thing we're going to talk about is power writing. And power writing really breaks down to a single tip. And I base this on many years of reading other people's writing and having to figure out why it's not working at just the, at the basic sentence level. At the paragraph level and the large-scale organization level of the whole document, usually what's not working is that things aren't in the order the reader expects. And that's really true at the sentence level, although the difference is we don't have, as legal writers, we don't come to law school, most of us don't. I will say this, paralegals and legal assistants sometimes do. But we don't come to law school with a bunch of bad legal writing habits because we don't have any legal writing habits. So usually we're pretty clean slates as far as organization at the paragraph level and at the document level. At the sentence level, though, at a minimum, everybody believes that they know how to put together a sentence, at least to some level. And that's certainly true. You can't get through this much education and not be able to put together a sentence. But to have some finesse at it and be able to do it in a way that is at a professional level of writing is really a different kind of animal. And what's sort of counterintuitive is that to do this at a professional level, what's needed isn't more complexity. What's needed is more simplicity. And so, I like sports metaphors because they work really well with writing because it's a skill and it's something you have to practice. If you watch the difference between like a little league game and a professional baseball game, little league kids, they make that look really hard. They make it look really hard to even get the ball all the way to home plate. They make it look hard to hit the ball. Like everything looks hard. Because it is hard for them. They don't know what they're doing yet. They don't have the skills, and so it looks hard. Professional baseball players make it look easy. We all stand out there. We're a huge baseball family. We watch lots and lots of baseball. And every single one of us is a complete and total expert about how to play baseball and what a player did wrong. And that's because they make it look easy. They make it look like, oh man, I could have caught that. There's no way I could have caught that. I can't even run down to the field. But they make it look really easy. And so really any sport kind of works that way where it looks easier than it is, and that's because they know exactly what they're doing. So what you're going for is simplicity. What you're going for is to make it look easy and to make it look simple. And the audience that you have, because, one thing I hear from students all the time is, well, if I make it simple, isn't my reader going to think I'm not intelligent? Aren't they going to think I'm dumbing it down? And the answer is no, because your readers are all also professional writers. And so they know how hard this is. So, professional writers recognize good professional writing from others, and they appreciate it. And because your audience is also made up of professional readers, they read a lot of legal writing, and by definition that means a lot of bad legal writing. So what we're going to strive for is simplicity. And so the main thing I want, the main tip I want to share with you is just a basic sentence structure tip that will serve you very, very well. And like I said, it's based on reading lots of people's writing over many years, and my observation has been that all of the bad writing really comes down to this one thing. It just comes down to this one thing, and that if you can do this one thing, you're way ahead of the game. Okay, so the thing is this. And it sounds ridiculously easy, but it is the truth. Okay, hold on. Let me share this again. Okay. So the thing is, you want a strong subject, you want an action verb, and you want them close together. Now, those of you who have already taken my first year course have heard me say that ad nauseum. You want a strong subject, an action verb, get them close together. But I don't believe there's too many times you can hear any of this stuff. So that's what we're going for. Strong subject, action verb, close together. I don't yet have a clever acronym for this. I should. If anyone wants to make one up, I'm happy to steal it from you. So that's what we're going for. This cures a multitude of ills. And so that's what I'm going to take you through today, is sort of the common problems that legal writers have and how this will solve all of those problems. And so the problems kind of basically, sorry, I've got something in the middle of my screen that you can see. So the first problem is, I'm going to call that passive voice overuse. The second problem is just basic obscure ideas where you just can't really get a handle on what the sentence is saying. And then the third big one is sentence fragments. Sentence fragments, oddly, plague legal writers more than I think they do any other kind of writing, because the sentences in legal writing can get away from the writer pretty easily. And so sentence fragments generally result from that. They're usually these long, super long phrases that look like sentences. After about 3 lines, as a writer, you think, surely I've got a sentence here and I can quit and go on to something else, and you place a period at the end of it, but it's not always there's not always a sentence there, and I'll show you how that works. So the first thing is passive voice overuse. And so remember I said that at the paragraph level and at the document level, it's a little bit easier to get things right, to organize things properly, because we have a set organization that you learn. You learn it early in law school and you practice it all the way through law school, ideally. And then you take that with you into practice, and if you do take that into practice, it will serve you well. So there's a basic structure. Some people call it IRAC, CREAC, whatever. There's another, so that's the basic paragraph structure, the basic argument structure. There's a basic document structure, which is at some point you're going to identify a problem, give the answer to the problem, give the facts that the problem relies on, and then give the argument for why the problem should be resolved the way you say it is. That's the organization that you see in memos, you see it in letters, you see it in trial briefs, you see it in appellate briefs. That's the basic document organization. And so sentences have a basic organization too, and it fits really well with what we're talking about in this course, because the basic structure of a sentence is a story. Someone did something to some effect. It either impacted someone or did something to someone or resulted in something. So someone did something. That's the basic structure of a sentence, is that someone did something. That is how we process information. We process information in stories. That's why we talk so much about narrative and persuasive writing, is because we have developed language over time and developed thought processes over time so that we are used to communicating in stories, we are used to understanding information in stories. That's why story is so persuasive. At the sentence level, your reader expects a little mini story, subject, verb. So you have the judge denied the motion. That's a basic story. Someone did something, so someone, is the judge, did something, denied, to something or someone equals the motion. So you've got a little mini story there, okay? The problem with passive voice is that you've got a story, but now it's told in reverse. Something had something done to it by someone. And so now the story is not as easy to understand. So now the action of the sentence, the organization of the sentence, goes backwards instead of forwards. And so it's as if suddenly the sentence was written in reverse order. And in fact, it is written in reverse order of how it happened. The motion was denied by the judge is exactly the opposite. So this makes it harder to understand what happened to the motion and who did what to the motion. And so the action here is reversed. Okay?
Professor Norton?
Yes.
What if you were saying a sentence, something along the lines of, to the defendant's dismay, the motion was denied by the judge? Would you just correct that to the judge denied the motion?
Denied by the judge. Yeah, you could just fix this part of it. And just, you know what? Hold on. I'm going to go into I'm going to put this in Word so I can do the show the track changes. Okay. So yeah, here you would just to the defendant's dismay, the judge denied the motion.
I'm not seeing anything on my screen.
Oh, sorry. Thank you. Thank you. Thank you. Ah, that's not what you should be seeing. Hold on, sorry. There we go. Yeah, so you would just change it to the defendant's dismay, the judge denied the motion. You make a good point though. And that is, you know, to what extent do you want to start your sentence with information like that? To what extent do you want to start a sentence with something other than the subject and the verb? And I would say generally very seldom. So let me show you a couple of other examples so you can see. Okay, so the object of the sentence, is to convey your mini story. And so to do that, you've got to get your mini story within the first couple of words of the sentence, or you really lose the reader. And so passive voice overuse takes a couple of different forms. And so the first one is just what you saw there, just the flipped story. Another kind of thing that you see is nominalizations. Nominalizations are another way that you end up actually with passive voice, even though it feels like you've got something in the sentence. And so, an example of a nominalization would be something like determinations of evidentiary. Oh, this is a good one. Okay, determinations are made by the judge. Okay, so there are several problems with this. The first one is that what you have in the subject position of your sentence isn't a person, because remember the first part of this is strong subject followed by an action verb, and to have those close together. So strong subject means a person or an institution. So a judge, a court, a plaintiff, a defendant, a witness, a victim, something like that. Determination is in fact a noun, but it's the nominalization, meaning the nounification basically, of a verb. The root verb there is to determine. And so, and similarly, admissibility, the root verb there is admission, or to admit. So you've got the story completely obscured. Determinations of evidentiary admissibility are made by the judge. Your subject down here is the judge. What the judge does is to determine, but you can't see that as a verb because it's been masked as a noun. The actual verb that is used in the sentence is made. But the judge isn't making anything. The judge isn't making determinations out of, paper like origami. Determination is actually a verb, and made is one of those really weak verbs, and there are many of them. Any form of the verb to be, verbs like make, involve, those are all really weak verbs that mask the actual action that the actor is conducting. So nominalization is the second kind of form of passive voice that really will obscure your writing. So again, to fix this, again, you've got to figure out who was doing the action. So here it's the judge. What does the judge do? The judge determines, and then you can do evidentiary admissibility. In this particular instance, admissibility of evidence would probably be a little bit easier because evidentiary admissibility uses evidentiary as an adjective, and you probably really want to focus on the fact that it's evidence more than the fact that it's evidentiary admissibility. So that's another form of the passive voice, and this is, again, the way to solve it is identify your subject, pair it with your verb, and then that's going to make the rest of the sentence flow. Okay? So, strong subject, action verb, close together. Let me show you what happens when you don't have them close together. And I'll go back, after we're done, I'll go back and clean this up and label these examples for you. So, the judge who has been on the bench for 25 years and who routinely rules in favor of the prosecution because he was a prosecutor himself for many years before taking the bench, determines admissibility of evidence. So here, hold on. So here, oh, let me move this up. Here what we have, we've got a strong subject.
Professor?
Yeah.
Professor?
Yeah.
Isn't that a run-on sentence?
It's not.
Okay.
I'm really glad you asked me that, and I want to put a pin in that and come back to it. Don't let me forget to answer that question. So you've got a strong subject, the judge. You've got an action verb, determines, but you're still in a jam. It's still intuitively. I mean, Andy looked at it and went, "Whoa, isn't that a run-on sentence?" It still is out of control because your subject and your verb aren't close together, and so all of the description that you might want to provide about the evidence or about the judge can't come between the subject and the verb, because if it does, it makes it harder for the reader to get that mini story. So again, going back to how we process information, what we do is something called chunking. We don't fully comprehend a piece of information until we have the subject and the verb. We've got to have at least the skeleton of the story before we comprehend it. Until then, the way I think of it is, it's like you have sort of a, like a basket or a filter of some kind on top of your brain. And the filter won't let the information through until you've got the subject and the verb. So in this sentence, you're just filling the basket full of information before it even goes into the brain, so that when it goes into the brain, it's just a ton of information to sort out. In the reader's brain, this kind of thing takes seconds. Passive voice, just a straightforward passive voice, the motion was denied by the judge, takes microseconds. But this actually takes full seconds to untangle. Every time you delay your reader's path through the sentence, they drop a little bit of comprehension. It makes it hard for them to retain the information in their memory, and so it makes it harder to get through that information to the next piece of information. What that results in is that feeling that you guys had throughout your entire first year, where it was like, I think I understand it, but it's a little murky and I can't quite get a handle on it. That's because you're dropping little bits of information. Now, in the first year, that's caused by two things. One of the things it's caused by is the fact that you're learning a new language. And it's very hard to comprehend that stuff in a new language because it's coming at you faster than you can decode it. But the other reason is so many of the opinions that you read in the first year are really older opinions. They're seminal opinions in civil procedure, God forbid, property, and those opinions are not written very clearly. They're very difficult to read, primarily because of things like this. Primarily because they don't have a strong subject and action verb close together. Okay, so the problem with this then is that you've got the strong subject, you've got the action verb, but they aren't close together, and so by the time your reader gets to the verb, the reader has forgotten what the subject was and is off sidetracked by this descriptive information. Okay. Now, Andy asks, isn't this a run-on sentence? It's not a run-on sentence. And the reason is that it has a subject and a verb. As long as it has a subject with a verb that goes with it, it's a complete sentence. This isn't even a comma splice is a type of run-on sentence where you just tack stuff together with commas. This isn't that, because these things aren't just joined with commas. This is a complete clause. From who down to bench, that's a complete clause. That's completely set off, and it's set off with a pair of commas, and so it's perfectly fine. So let me, as sort of an aside, I'll throw this in. You can separate your subject from your verb with 2 commas, as I've done here. You can't separate them with 1 comma. You can't ever separate your subject from your verb with 1 comma and have that be correct. That's never going to be correct. The subject and the verb are a single unit. Commas are a type of parenthetical punctuation. Okay? Now, they serve multiple functions. They're not always parenthetical, but here they serve the function of parenthetical punctuation. Commas, parentheses, and the brackets and braces, those all serve the function of information that's sort of set aside, that's additional information for the sentence, that doesn't really, that's not really part of the basic structure of the sentence. So if you use 2 commas to parenthetically set information off, that's okay. But a single comma is always going to be wrong. So I just want to throw that in there because that's a good place to make that point. So, again, you've got to have the strong subject. You've got to have, let's see. Okay. So here, my point is strong subject. Here, my point is action verb. And then here, our point is that we got to have them close together. Okay? So that's the basic technique. The basic technique is a strong subject, an action verb, and close together. Okay, I thought somebody had a question. Okay, so the other form of passive voice overuse is some version of what some people call postponed subjects. People call them lots of different things, but it's the same problem. And it's when you start a sentence with it is, there are, there were. It's either it or there with some form of the verb to be, where it and there don't refer to anything, where they're just placeholders. Okay. So, here, an example of that would be,
Professor?
Yep.
You might be getting to this, but my problem with the it is or is there or whatever is that I'm trying not to be repetitive with the subject. So in a sentence, I'm trying, like the sentence before might see the ADA, and then the next sentence might say it, to avoid saying the ADA, the ADA, the ADA. Or is this something different?
This is something different. In that situation, you're talking about, you know, the ADA did X, and then it referring to the ADA, correct?
Correct.
That's not this.
Okay.
This is where it and there don't actually refer to anything.
Okay.
So, something like, it is clear that the judge denied the motion. Okay? It is clear that doesn't tell the mini story you're trying to tell. The mini story you're trying to tell is the judge denied the motion. And so there are two problems with this. In addition to needing a strong subject, action, verb, and having them close together, the other technique that goes with this that you need to keep in mind is that there are two valuable pieces of real estate in each sentence. And that is the beginning and the end. And so the beginning of the sentence is, it is clear, and the end of the sentence is, the motion. The middle of the sentence, the judge denied, is the part that the reader is most likely to skim over. And so you've lost your most important point, which is that the judge denied something, because you put it in the middle of the sentence. So the problem with these it is, there are, is that they postpone the subject and they put in its place something that is essentially filler. It's wood chips, it's marshmallows, it's whatever. It's just filler. It doesn't actually serve any purpose. It doesn't tell the mini story of the sentence. It doesn't advance the analysis from the previous sentence. It's just gap filler. And the problem is, when you place gap filler in such a strategic place, your reader loses what you really want them to focus on, and then they're a little bit lost as they go forward. The other problem with this, just from a strategy perspective, is that if it is in fact clear, then you don't have to say it's clear. If it's not clear, saying it's clear won't make it so. Okay? So, in that sentence, you just cut it off. The judge denied the motion. Okay, so let's look at one that's a little bit harder for a lot of people to figure out what to do with. There are 4 elements to negligence. They are duty, breach, causation, and harm. Okay. So the question is, you have a sentence like that and you're like, but I don't know how to fix that, because I'm just saying that, negligence has 4 elements. There's not any action, it's just a state of being. That just is a fact. And so, that's true, But you could go something like this. The elements of negligence are duty, breach, causation, and harm. Or if you wanted to get out of passive voice, or not passive voice, out of the verb to be altogether, you can write something like whoops. You can make it more active altogether. A defendant will be found liable for negligence when he has a duty that he breaches causing harm, or even better, when he when he breaches a duty causing harm, or when he breaches a duty and causes harm. So you can go to something that's a lot more active instead of just stating things in a list form. So either one of these is acceptable, this one or this one, but you just want to get away from that there are, because if your point is that there are 4 elements to negligence, you've sort of lost the 4 elements part. Now, I'm giving you short sentences as examples because it's easier to see these things in short sentences than to start off looking at the really long sentences that are convoluted. This kind of sentence is easier, obviously, because it's shorter for a reader to translate and sort of get the story from. But once you take this same issue with the there are and put it into a longer sentence, the whole issue becomes a lot more critical. Also, there are 4 elements to negligence: or duty, breach, causation, and harm. That's boring. In addition to the other problems, it's just boring. Nobody wants to read a story about the elements of negligence. Nobody wants to hear a case about the elements of negligence. And so it's not very interesting on top of everything else with it. Okay, so that's the it is, there is, the there are. What's the next thing? Obscure ideas. That goes back to the nominalizations. Determinations of evidentiary admissibility are made by the judge, and many sentences like that. So anytime you have a nominalization, which is the noun form with the ION of a verb, or any abstraction, anything that's not a person, in the subject sentence, you end up with an obscure idea. So we had the motion was denied by the judge. Admissibility of evidence is determined by the judge. Determinations are made by the judge. In all of those instances, you've got something other than an actor, an actual actor, as the subject of your sentence. And so that's going to obscure the meaning of the sentence and make it harder to understand. Next thing, sentence fragments. Okay, now this goes back to Andy's question on that other one about whether or not that sentence was a run-on sentence. And so there are two issues, 2 major issues that this solves, and those are run-on sentences and fragments. And those are opposite sides of the coin, not the corn. A run-on sentence is a sentence that doesn't have a verb. It's got a subject, but it doesn't have a verb. And so, let me give you an example. The defendant, who had been twice convicted for assault, convictions which arose from juvenile arrest during the time he was in a juvenile detention facility run by the county over which this judge has jurisdiction. Okay, you got a 4-line sentence-ish. You get to the end of that and you're like, oh yeah, that's lots of information. I'll put a period on that and I'm done. But you're not done, and the reason is the defendant hasn't done anything yet. All of this is descriptive information about the defendant, but the defendant has yet to do anything. And so when that happens, and that's sort of the, you know, what Andy was looking at, she was like, there's something wrong there. There's something wrong there. So here, this is the flip. Go ahead, Andy.
I'm sorry, Professor. A run-on sentence is more about, this is like a silly question, is more about the structure of the sentence than the grammar of the sentence. Because in this one, you have your commas and, you know, but it seems to me that it's a run-on just because of the structure of it.
A run-on,
rather than the fact that there's commas.
A run-on sentence. Yeah, a run-on sentence is not a sentence that runs on, so it's sort of bad. It's sort of bad nomenclature there. A run-on sentence isn't simply a lengthy sentence. You can have a very lengthy sentence, and it can be perfectly correct. In fact, the one we had up here. Let me paste that down here.
Up there.
Yeah. So this sentence. This is a complete sentence. There's absolutely nothing wrong with this sentence other than stylistically the subject and the verb aren't close together, which is going to make it harder to comprehend than it needs to be. But it's a complete sentence. It's perfectly fine. Okay? This is a fragment because the defendant is the subject, but there's no action that goes with the subject. Okay? So this is a fragment. And that's part of the danger of these really long sentences is that they start to get away from you. And you, as the writer, you feel like you've said enough to have a sentence, but you haven't. And the problem is you've sort of gotten distracted by your own side information. A run-on sentence... Okay, this is a run-on. The reason it's a run-on is that, and this is also a comma splice, is that it's got several complete clauses, but they're not joined properly. It's got several completely independent clauses, but they're not joined properly. So, I just met you and this is crazy. That is an independent clause. That can stand on its own. Okay? Here's my number is another complete clause. Call me maybe is another complete clause. These are all independent clauses. You don't join independent clauses with commas. Okay? Now, you could fix this. Can you fix this? Yeah, this one is easiest to fix with either periods or semicolons. So, semicolon, here's my number. You could fix it that way, or you could fix it with periods and separate them out. So a run-on sentence is one where you've got a complete sentence and then you just tack another either dependent or independent clause onto it with, or not dependent, another independent clause onto it with just a comma. You just tack it on there. So a run-on sentence is more about punctuation. It's more about signage. Have you given the reader the proper guidance about how these ideas fit together? Okay? Whereas a fragment is about whether you have a complete thought yet. And that idea of a complete thought or a complete sentence, that goes back to what I was saying, that your reader's not going to comprehend it, you're not going to understand it until you've got the mini story. You've got to have the skeleton of the mini story. You got to have who did what. And only then is it a complete thought that the reader can digest. So, this technique can help you with both of those things. Because, and run-on sentences I don't see as much of. I see them really pretty rarely. Most law students are perfectly adept at not letting the sentence go into to multiple complete sentences joined by a comma. The fragment is what I see because the sentence gets away from you. Okay. So the way that you fix all of this.
Professor Norton?
Yes?
Oh, I'm sorry. When you're finished your thought with this, I had a question, but I thought you were going to stop for a second.
I am going to say, go ahead. This is a really good place to take questions.
Okay. Just curious, you had said something about having a strong subject. What makes a subject strong?
That's a great question. A strong subject is someone capable of doing something or an institution capable of doing something. So, for example, determination is a concept. Okay? Determination can't do anything. A judge can do something. A jury can do something. Basically anything with power to act is a strong subject. The court, the legislature, the judge, a plaintiff, the defendant, the victim, the witness. That's what makes it a strong subject. It's something that has the power to act rather than just the power to be. Determination can be, but it can't do anything. Determination can't throw a ball. Determination can't sign an order. Determination can't make law. Okay? Does that help?
That does.
Okay. And so then you want to pair that with an action verb that's descriptive. And this is really the heart of persuasive writing because you guys have learned a ton of techniques, but if you're not aware of what's going on at the sentence level, the techniques are really all going to be very watered down. Okay? Okay. So this is all about clear, powerful writing. This is how you have clear, powerful writing. There are times when you don't want clear, powerful writing. And that is really the next level. And that's really, along the lines of what we're talking about with this class, which is taking things to the next level, beyond the basics and into the next level. And the next level of this is not just knowing how to write powerfully, but knowing when to write weakly. Because passive voice is not evil. It's just that passive voice has a particular function. And the function of passive voice is to obscure. There are times when you want to obscure. There are times where your client has behaved improperly, and you might want to obscure. There are times where you don't want your client's actions within those two valuable pieces of real estate. You want your client's actions in the swampland of the middle of the sentence because you want the reader to skim over it. And so it's not just about, here are some techniques, and if I use these, it'll always be okay. They're all techniques. Even the weak writing is a technique that you can employ to your benefit. Okay? Now, the exception to that is fragments and run-on sentences. Those are just wrong. 100% of the time, they're absolutely wrong. They're just wrong. Okay? Judges won't like them. Judges won't appreciate them. The trial brief that I showed you guys, that was from the practicing attorney, the one that was so emotional and so sort of personal in its attacks on the opposing party. That one had a ton of fragments in it. Now, they were done for effect. They were purposeful. I understand why they were. I don't think the guy was illiterate by any stretch of the imagination. He knew those were fragments, and he used them on purpose. And he used them to achieve a particular effect. It ended up not being an effect worth achieving, and so I would be careful with that. I would really avoid what some might call the strategic use of sentence fragments. They're not a good idea. And run-on sentences, there's really not a strategic use for run-on sentences. You can achieve the same thing without signaling to your reader that you don't know what a run-on sentence is. So here's the strategy. Here's what you need to do. Here's how you're going to catch this
Professor?
stuff. Yeah.
Sorry.
No, it's okay. Go
I'm full
ahead.
of questions today.
That's okay.
I'm assuming that if we make any changes like these, as far as sentence structure, anything like that, in our final paper, that we should annotate it?
Absolutely. Absolutely.
Okay.
Yeah. And likewise, if there's a sentence that does have passive voice in it, I'm going to assume that wasn't strategic unless you tell me that in an annotation. I'm going to assume it was just writing that you couldn't figure out what to do with. So if you leave something that's passive, which is a perfectly acceptable strategy sometimes, indicate that you've done that. Okay. So what you'll do to identify this stuff is in each one of your sentences, you're going to underline the subject once, you're going to underline the verb twice, and you're going to ask yourself 3 questions. Is whatever I have in the subject position really the actor of this sentence? Is the verb I have assigned this actor a descriptive action verb? Determined versus made a determination? 3, do I have them as close together as I can? Okay. With regard to that third question, and we'll go back to this sentence, the judge who's been on the bench for 25 years. So what do you do with a sentence like this? Well, it's actually pretty simple. You take the descriptive information and move it on the other side of the subject-verb chunk. Okay? So all of this description is for the judge, so you could say this about the judge beforehand. The judge in this case has been on the bench, blah, 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 blah. And then that's its own sentence now. He will determine admissibility of evidence. Or, even better, he will determine whether to admit this evidence. So see, you've got admissibility and you've turned it into to admit. So the judge in this case has been on the bench for 25 years, routinely rules in favor of the prosecution because he was a prosecutor himself for many years before taking the bench, determines admissibility of evidence. So now that's its own sentence, and then the action part that he will determine whether to admit this evidence is its own sentence. So it's not a difficult fix, but you want to make sure if the modifier had modified evidence, you get that. If it had modified evidence, you would probably get it on the other side of determines. So anytime you've got that modifying information that attempts to hijack, really anything between your subject and your verb, unless it's very, like here, we've got in this case. That's fine. That's small enough. Judge in this case is a manageable subject. You can, the reader can deal with that. But anything that starts to get beyond a few words, you want to take that and either move it into its own sentence or move it at least as a phrase before the subject. Okay? Okay. Does anybody have questions about this before we move on to citation?
Hi, I have a question actually.
Yeah, Shauna.
In respect to using passive voice, it was my understanding that when you are discussing the opponent's argument in your paper, that you can utilize passive voice also in order to, I guess, downplay your opponent's argument?
Sure.
That is.
Yeah.
Okay.
Yeah. Yeah, you can do that. You can do that. Although, sometimes you don't. Again, that's a strategic decision. You may not always want to do that. Sometimes, you may want to point out. You may want to point out that their argument is illogical, and so you want to state their argument as directly as you can to point out, why it doesn't work or what the hole in the argument is. So yeah, but it's definitely a tool you can use to undercut your opponent's argument. Absolutely. Any other questions? Okay.
I actually have more questions.
Okay, great.
Sorry. It's actually about the paper. I just wanted to make sure, when I'm making changes, we talked about changes such as sentence fragments, if you're and such. But when I'm making grammatical changes, should I annotate that as well? I just want to make sure. I just want to annotate as much as I'm supposed to be annotating. Absolutely. Anything you change, you're changing for a reason. I mean, you guys aren't just going to tinker with stuff just to change words, just to change them. There's going to be a reason that you change it, and you want to document that reason. Okay. And I just want to verify the parts of the brief that are supposed to be that we're supposed to be handing in. We're supposed to be handing in a cover page, the table of context, and the argument section. Is that correct?
Okay, your cover page, your table of authorities, not your table of contents, your statement of the case or statement of facts, whichever it's called, and your argument.
Okay.
Yeah.
Thank you.
Any other questions before we go on to citation? Okay. So let me open up a new document. Okay, so now we're going to go on to citation, and I'm looking around my desk to pick. I want to pick just a random citation. Let me see if I can find something. Oh, I know what I'll do. I have many citations in this set of book edits. Okay.
Professor Norton?
Yep.
You'll be posting these documents?
I will. Yeah, I will. I'll post them. Yeah.
Okay.
What I'll do is I'll add a folder on Twin for just these sessions, and I'll post the recordings and the documents in there.
Perfect. Thank you.
You bet. Okay. So I'm going to pull up a site on Westlaw and then show you guys the information, because it helps sometimes to start working with the information from what it looks like on the screen. is not doing what I want it to do. There we go. That's not what I wanted it to do. There we go. Okay, let me make that larger. Okay, so this is the information for a citation off of Westlaw, and so this is where we start. Okay, so citation sentences, like every other sentence, have a grammar to them. Okay, and so the basic grammar of a citation sentence. Let me get back into a new document. The basic grammar of a citation sentence is that we need something to call it. We need to know where to find it. And we need to know what the weight of it is. And so every citation is going to contain that information. So, for example, for a case citation, you have the case name, bad example, the case name, the location, where to find it, and then the weight of it. And so for the U.S. Supreme Court, of course, that's the only court that you don't put anything in the parenthetical. And so this gives us the weight. So we've got the name, we've got something we can call it, we've got where to find it, and we've got the weight of the authority. We need these things because, first of all, we're going to refer to the cases or the statutes or the secondary source throughout the argument. And not only in the document itself, but when you do oral arguments, you guys know from your own experience, you're going to refer to cases. So you've got to have something handy to call it that's not too long and too onerous. You don't want it to be too long for purposes of oral argument. You don't want it to be too long for purposes of your document because you don't want your citation to take over your document. So, so you've got to have something to call it. You've got to know where to find it because legal writing is competitive writing. What that means is that people don't just take your word for what you say. They're going to go look up your sources, and your opponent is going to try to poke holes in your argument based on how you use those sources. And so everybody's got to know where to find that information. Okay, so where to find it. And then finally, the weight of it. Your reader needs to be able to look at the citation and from just the citation know if it's persuasive or it's binding. And so that's why you've got to include that information. So this is the minimal amount of information that a reader needs out of an author in legal writing. Okay? The same is true for statutes. You've got to know what to call it, where to find it, and what the weight is. And so, let's say, for example, we have, I'm just making one up completely off the top of my head. This is not an actual, or let me see if I can find an actual statute. Hold on. Okay, this is not worth it. I'm not finding what I want. Oh, wait. Oh, I just found one. Okay. Okay. So, Okay. With statutes, it's the same. You've got to have something to call it and a place to find it. Now, with statutes, sometimes we just call it by its number, by its statutory name and number. Sometimes, sometimes we use the actual name for it. So let's say, again, I'm just making this up. Defensive Poultry, Oklahoma Stat, and okay. Okay, so we've got to have something to call it, where to find it, and information that tells us that the weight of it. So again, we've got the name, either Title 21, Section 692 of Oklahoma Statutes Annotated, or we could call it the Defensive Poultry Act. We've got where to find it. You're going to look at Oklahoma Statutes Annotated, Title 21, Section 692, and how authoritative it is. It's from the West publication published in 2000, the version published in 2011. If you find it online, of course, you indicate what it's current through online. So statutes work the same way. For that reason, because you've also got to be able to tell the reader where to find it, let's say that you also want to cite the next section, Section 693, but let's say that next section is in the pocket part. You indicate that it's in the pocket part with sup, with sup, and that would be the date of the sup. Or if it's in, let's say that the section that you're going to cite, 694 now, is partially in the main volume and partially in the supplement. So you've got to indicate where the reader's going to find that. Okay, so that's 3 pieces of information you've got to have for everything. It works the same way with secondary sources. You got to have a name to call it. You got to have the place to find it, and then the weight of it, indicating for secondary sources that would be the year that it was published. Same for administrative regulations, same for legislative history, for everything. Something to call it, where to find it, and then the weight of it. Okay? So those are the basics. Okay? So let's put together a citation based on that. Where are my windows? Okay. So starting with case citation. With case citation, there are 2 steps to doing the case name first, what we're going to call this thing. And they are eliminate and abbreviate. Rule 10 of the Blue Book, in what used to be in B4 of the Blue Pages is now B10 of the Blue Pages in the 20th edition. A new edition of the Blue Book just came out last month. So what's now B10 of the Blue Book. And if you don't, unless you're going to be on law review, I wouldn't run out and get a 20th edition of the Blue Book, because things have been moved around, but not much has changed. Electronic citations have changed. So if you're going to be citing something to the internet, you need to get a hold of the 20th edition. But as far as print things, very, very little has changed. So I wouldn't say it's worth your money to get a 20th edition. So eliminate and abbreviate. So Rule 10 and Rule B10 in the Blue Pages tells you the things that you want to eliminate. And so you need to know generally what those things are. And so generally speaking, it is anything descriptive about a party, anything indicating multiple parties, first names of people, but for example, here you've got Daniel Goodman, petitioner, appellee. You would get rid of Daniel because this is a person, but if it was Daniel Goodman Automotive, you wouldn't get rid of Daniel because that's part of a business name, and we don't change business names. Things that are repetitive, we get rid of. So, for example, if you've got two business firm designations like company and incorporated, you only include the first one, you get rid of the second one. So generally anything that's repetitive or descriptive, you get rid of. So here we have Daniel Goodman, petitioner appellee, versus Chris Ward, respondent appellant. So we're going to retain, that is a very small font. Let's make that a bigger font. We're going to retain Goodman. We're going to get rid of Daniel because we don't use first names. We're going to get rid of petitioner appellee because we don't keep descriptive information. And then we'll go on to V period. It's always V period. It's not versus. It's not VS period. Even though sometimes on court documents, particularly in federal court, sometimes the sort of the tradition within a particular court is to use VS period on the documents. You don't use it in citations. And then the next party, Chris Ward, respondent appellant. And then you have all these other people. The beauty of the citation rules is you don't care about all those other people because you only list the first party on each side. And so all of that stuff is just complete noise. You don't need it. All you need is Ward. You need the first party and you need something to call the first party. You don't need anything descriptive. You don't need anything about multiple parties. Sometimes you have consolidated actions where you have Goodman versus Ward, and then the next one is, it's consolidated with an action of Smith versus Jones. In that case, it's still just Goodman versus Ward. First action, first party on each side, no descriptive terms. So really, really basic. So Goodman versus Ward, comma and a space. So now we've got something to call the case. Next, we're going to go into where do we find the case. Here, we find the case in two places. You can tell from here. You've got the regional reporter site, Northeastern Reporter Second, and you've got Illinois Appellate Reports Third Series. This is a state court site, and anytime you have state court sites, you need to think about whether you need a parallel citation. Okay? A parallel citation is simply citations to the multiple reporters in which the opinion might appear. If you look at the top of, let me go grab one. No, don't have it there. If you look at the, yeah.
I just have a question. My professor didn't require parallel citations for our appellate brief. Do you require parallel citations?
Well, hold on. That question's going to kind of answer itself. Okay, so the rule for parallel citations with state court is that if you are citing a decision of a state that uses multiple reporters, and you are citing it to a court in that state, then you need parallel citations. Okay? So this is an Illinois case. If I'm citing this to an Illinois court, I need to include the parallel citations. Why? Because Illinois courts and Illinois practitioners may have either one of these reporters, but may not have both. Whereas practitioners and judges in other states, if they have either one of these, they're only going to have the regional reporter. So there's no need to even include the parallel cite when you're citing to a court outside of that state. So to answer your question, Shauna, the only time you need parallel citations is if you are citing a court, if you are citing a decision of your state's court to that court. So if you're citing a New York case to a New York court, you need parallel citations. Those of you who have fictional jurisdictions for your assignments that you wrote the document for, there's no, you're writing to a court, but there are no decisions of that court, right? It's a fictional court. So all of your decisions will be from either federal jurisdictions or from other states, which means parallel sites aren't even an issue. Okay? So the only way it could be an issue is if you're citing cases from a state to that state's court. So citing New York cases to a New York court, citing New Jersey cases to a New Jersey court, etc. This only applies to state courts. For federal courts, there is no parallel citation. Okay? The other thing with parallel citation is that you only cite either regional, state, or federal reporters. You don't ever cite subject matter reporters. For example, like the education law reporter, the employment law reporter, the BNA Weekly. You don't ever cite any of those other things. You only cite either a regional, a state reporter, or a federal reporter. Okay? So unless you're citing a state's court decisions to that court, or to a court in that state, you don't need to worry about parallels. So we're assuming we're going to cite this to, let's say, a New York court. We don't need to worry about parallel citations. We only include the regional reporter. And so the regional reporter is Northeastern Reporter 2nd Series. And so 922nd, Northeast 2nd, 522. Okay, so now we've got the location. We've got something to call it. We've got a location. Now we need to indicate the weight. It's an Illinois appellate court case. And so, hold on, let me grab my blue book. The easiest thing to do, and I know that law students, particularly after the first year, are like, oh, no, I don't need to look anything up. I've been doing this for, I have owned a blue book for going on 25 years now, and I still look them up. Even if it's New York, even if it's Texas, I still look them up, because there's the one time I don't look it up, there's going to be some kind of hinky citation that makes me look stupid. So this is an Illinois appellate court. So I'm looking in the Illinois section of T1.3 in the blue book. And under appellate court, it tells me that the abbreviation is ILAPCT. And then a space, and the year of decision is 2010. And so that is the end of that. And then I'm going to italicize it. Okay, a couple of things. As far as the spacing between Northeast 2nd and Illinois Appellate Court, the reason that Northeast 2nd has no spaces is because it's all single capital letters. Ordinals, 1st, 2nd, 3rd, 4th, 5th, 6th, on like that, are considered single capital letters. You do not space between a single capital letter and another, well, yeah, between single capital letters. The reason that you have spaces between Illinois appellate and court is because they are longer abbreviations, longer meaning anything more than a single capital letter or ordinal. So ILAP court, all of those are longer abbreviations, so there's going to be a space between each one. Okay, that's the rule for all abbreviations in Blue Book citation. If it's a longer abbreviation, you space between. If it's a single capital letter, you don't. Okay. Okay. So what happens when I have, let's say that I have for the district, yeah. For example, Maryland has a single district court. So how would I abbreviate the District Court of Maryland? District Court is going to be abbreviated just D period, and Maryland is going to be abbreviated MD period. So you've got a single capital letter and a longer abbreviation. Because you have a longer abbreviation, that longer abbreviation is going to take a space on either side, which means you'll have a space between D and Maryland. Okay? In contrast, the district court for the District of Columbia, D is the abbreviation for district court. The abbreviation for District of Columbia is DC. It's just DDC. There's no spaces between them. You don't space between the abbreviation for district court and the jurisdiction. It's just all single capital letters, so it's all together. Okay? Okay. Let's see. What else about this? So let me give you one that has some longer abbreviations. So I'm going to give you one that has more to deal with than just single party names. Okay. So again, with the party name, Lindsay Smith and. Once you hit and, you're done. You've seen everything you need to see. We only include the first party, and we only include the last name if it's a person. All of those descriptive terms, we're not worried about. So our first party name is just Smith. Then we have the University of Detroit, a Michigan corporation, defendant appellee. Okay. A Michigan corporation is a descriptive piece of information. We don't include descriptions. Defendant appellee is descriptive. We don't include descriptions. So we only need the University of Detroit. So the first thing we need to know is there anything from University of Detroit that we eliminate? And there is. We always eliminate the word the. And so we're going to be left with University of Detroit. Okay? So we've done all the elimination that we need to do. Now we go on to the second step, which is abbreviation. And so we look in T6 and we see that university is abbreviated UNIV. Of is we leave just the way it is. Detroit is going to have to be abbreviated according to, whoops, hold on. Let me get the right table. I don't want to tell you the wrong table name. Alright, hold on. There we go. It is in T10 under cities. Oh wait, that one's not under cities. Sorry. Oh, that's really interesting that it's not in there. Okay, so we can get the abbreviation from Detroit. It's not under cities, so we can get it from going to... Oh, okay. Sorry. It's not under there, so we're just going to leave it the way it is. So University of Detroit. Now we're going to go to the reporter information. Again, we've got a Michigan case. We're not going to be filing in a Michigan court, so we don't have to give parallel citations. So we're only concerned about the abbreviation for, the location information for the regional reporter. So we've got that. Again, NW second, we don't need any spaces between those because those are all treated as single capital letters. And now we've got our weight of authority. Not our weight of authority, sorry. Our court and date parenthetical. Michigan Appellate Court. And so we're going to turn to the Michigan section of T1. Hold on, I'm getting there. Michigan. So I look and it's Michigan Court App. Notice that the Illinois was Illinois App Court, and this is Michigan Court App. That's why I looked this stuff up. It's hinky for every single jurisdiction. Michigan Court and App are all longer abbreviations, longer than a single letter, which means that we're going to space between them. And then the year is 1985. Close that. Abbreviate that. Okay? And so there's our citation. So again, with the case name, it's eliminate and abbreviate. You got to provide a location. You got to provide weight of authority information. Okay? Are there any questions about case citations? Do you guys have some case citations from your documents that you're struggling with that we could go through? Anybody?
Yeah, Professor Norton, I have one. I'm gonna cut and paste it into the
Well, just give me the basic. Just give me the basic site information. What's the reporter?
That's what I was a little unsure about, but it was a case that was cited from the New York State Appellate Division.
Okay.
So I wasn't sure when I was looking through the blue book how to, I guess, identify the court. That was what my problem was, as far as like if it was a federal court or the appellate division was considered like a state court. I was completely lost about how to do it, so that's what I was.
Okay, so what information do you have for it?
I was. Oh, hold on one second. Maybe you should just go on to the next question. Let me just get this together.
Okay.
For whatever reason, I can't pull up the document.
Okay, that's fine. Does anybody else have a citation that they're having trouble with?
I have one, Professor. I'm just trying to find it.
Okay. Anybody else? We have time to run through several. And of course, you know, as with everything, it helps, you know, even if it's not your citation, it helps to, you know, just to do the run through.
I put it into the chat box.
Fantastic. No wonder you don't know what to do with that. That is a bear.
That makes me feel better.
Okay. So, what jurisdiction is that?
Let me double check.
Start with, is it federal or it's federal, right?
Yes, I believe it is.
Okay. So let me see. Doe versus Mark Bates and Yoko. Okay, this is a great one. This is a great one. Okay, so what Andy has is a this is really interesting. Okay, so looking at the case, before the court are plaintiff's objections to report and recommendation by Magistrate Judge Craven. In this report and recommendation, the Magistrate Judge recommends granting Defendant Yahoo Inc.'s motion to dismiss. On matters referred to the Magistrate, the District Court makes a de novo determination. The district court may accept, reject, or modify. The court finds that Yahoo's motion to dismiss should be granted. Okay, so this is basically just an order granting dismissal at the trial court level, which...
Hang on. Professor, do you want me to copy the whole thing for you? Like,
I've got it. No, I've got it.
Okay.
And this is,
Sorry.
oh, this is kind of fun. This is out of, who are those people? This is out of my hometown, actually, where I grew up, Texarkana. Okay, so this is an order on a motion to dismiss. This isn't a final, Yahoo's motion to dismiss. Yeah, so it looks like, my guess is that this doesn't dispose of all claims and all parties, or it would be published, but it's not published. So that's interesting. Excuse me. Okay. So what we have here is an opinion that is available only electronically. So this is where you actually kind of do need, I mean, the 19th edition will basically get you there. So the rule for that is, let me grab my 19th edition. Okay, so it's in Rule 10. That's what I'm flipping over to. And, oh, here it is. 10.8, pending and unreported cases. And so this is a case that is unreported, and so we're going to use this rule to get us there. So the first thing is, okay, so let me print this for you guys.
I don't even know where I got this site from.
There, you know, the thing is, when you do research, it, you know, there's no telling what it's going to turn out. Okay, so this is the site. This is the information off of Westlaw for the site. So the first thing let's do is let's not get too bugged out about the location information. And first, let's just worry about the case name. So this is super easy because it's Johnny Doe. So Doe. A minor son of John and Jane Doe, that's descriptive, we don't need it. Plaintiff, descriptive, we don't need it. Versus Mark Bates and Yahoo. Yahoo is a second party. We don't use second parties. We only do the first party. And then defendants, that's descriptive material. We don't need it. We get rid of that. So Doe versus Bates. Now the location information. For a pending or unreported case that's available on electronic media, that's Section A of 10.8.1. And you can read through the rule, but you can also just look at the example here. And it tells you that you're going to have to include, first of all, the docket number. And so the docket number is right here. Okay, so there's the docket number, and then a comma, and then we're going to include the information from Westlaw, and we're going to go down to, if you'll look at if you've got your blue book with you, if you look at the fourth example is a Westlaw example, and so 2006 WL 3813758. And then the next piece of information that you're going to need is the court. So it's the Eastern District of Texas is the court. And then you need, for electronic sites, you give the exact date, not just the year. So December 27th, 2006, period. Italicized Doe versus Bates, and there you have it. So again, you've got something to call it, you've got the location of it, and then you've got the information that tells the weight of it, where it was decided, when it was decided. Okay? Oh, I see the next one. Chantel, is that yours?
Yes.
Okay.
That is mine.
Okay. So let me,
Okay.
yeah.
In that fourth example, they have an asterisk and a 1. Why do they have that in there?
That is a
Anything
pinpoint.
like that, no.
Yeah, that's a pinpoint site. And so if you wanted
Okay.
to cite to if you wanted to do a pinpoint site, you use the star paging. Yeah. And
This is star paging.
yeah. Yeah.
Ah, okay.
But for this, you know, it
Before you go on to the next one, when you have the pin site, I'm used to saying like at wherever it is.
right. So okay, so I've got the case here. So let's say I want to cite, whoops. Okay, let me get down to a part that's worth citing. Okay, here we go. I've got a statement here that says, Congress chose to immunize service providers to avoid any such restrictive effect. Okay, so I'm looking at the case. Let me share this screen with you guys. Okay, so now what you guys have is the screen I have up on Westlaw. And there's a sentence. I'm highlighting this sentence. So this is the sentence that I want to cite, okay? And I have to decide where to cite it. Now, for an unreported case or a pending case, it's not going to have reporter page numbers, right? So I can't cite to those reporter page numbers. Instead, I'm going to have to cite to screen page numbers. And so screen page numbers, of course, start at 1, you know. So here, I know it's super tiny, but there's a asterisk 1, which tells me that's my first screen number. And so now I'm going to look, there's asterisk 2, so that's where the second page starts. There's asterisk 3, where the third page starts. There's asterisk 4, and here is my statement. So that means that this statement is on screen page 4 of this opinion. So let me go back to our not what I wanted. Hold on. There we go. So screen page 4. So I'll do at asterisk 4.
What about the situations where there's, you know what, let me find one to show you what I'm talking about. When you want to reference in a citation a specific sentence and it has the number, you know what I'm talking about? I'll find one.
Are you talking about like line numbers?
Yeah.
That's for
So when you say like at 8:46, I think you only do it in a short site.
the only time you cite line numbers is for record sites. You don't cite line numbers for cases or statutes or secondary
Okay,
sources.
so I just put one in, and it's kind of what I'm talking about, and it shows, because you know how like in the cases there's numbers that refer to each different reporter.
So, okay.
A pin site, I think it's called.
Hold on, let me put this up here. Okay, so this is the site you gave me. And so what's your question?
See where it says at 8:46?
Right.
That's proper, right? Because it refers to a line, like a section of the case.
No. I don't know, like, I don't recognize what that would be. Okay, a couple things. First of all, as the reader, I'm not counting to line 846. I don't care how good your brief is.
They're in the cases. Hold on. Let me get the case up and I'll show it to you. I'll email it to you, I guess. Just so that...
Okay, I'll tell you what, Andy, stick around after and let me do that, because this is not a thing.
Okay.
It's just not a thing, and so let's do it after, because this isn't going to happen to anybody else, I swear. In fact, I'm not kidding. In almost 25 years, I've never seen this.
Oh my God.
Like, this is the first time I'm seeing this ever.
Okay.
Yeah, but we'll talk about it, and I'll see where the confusion is.
Okay.
Okay. Does anybody else have a site? Chantel, you had another one. Oh, no, you had one we hadn't gotten to yet. Sorry. Okay, so Jacob and Young's.
So I was just, because I know you said that we kind of eliminate any type of second party, but because Jacob and Young is the name of the, I guess, of the construction company in this case, include the whole Jacob and Young and the Inc. part, or we just put Jacob v. Kent.
Okay, so what I'm going to do is, yeah. Okay, so hold on just a second, and let me pull the case itself up to see what information we're starting with. Oh, and this is a good one. This has a lot of good information for us. Okay, so here's the information that you get on Westlaw. Okay, so Jacob and Young's Incorporated. You're right. Jacob and Young's is the name of the business. So it'll be Jacob and Young's, Inc. And of course we get rid of respondent versus Kent, because it's a person's name. So we get rid of the first name and the middle initial, and we get rid of the descriptive terms. Then we're going to go to the, hold on just a second. So then we're going to go to the parallel site information, and we're going to start with, hold on, I want to get over to that rule so I can tell you where to look. Parallel citation. You're going to start with the state court information, and you can find that in your 19th edition. It's in, hold on, it's in B4.1.3, but it's way down, so it's like right before B4.1.4. In the 20th edition, it's right before B10.1.4. So we're going to start with the state court information, the state reporter information, 239. Then we'll parallel cite, because presumably you're citing a New York case to a New York court. Now we're going to do the regional information. Now, notice that there's also a citation there to an ALR annotation. We don't ever cite ALRs. We don't ever give the parallel cite to ALR, so you're going to leave that off. Now, for the court and the date information, you are going to eliminate anything that is apparent from the reporter abbreviation. So ordinarily, the abbreviation for the New York Court of Appeals is NY, and then the year of decision is 1921. But we're not going to include NY because you can tell it's a New York Court of Appeals decision because the New York Court of Appeals reporter is cited. So that makes the New York the abbreviation for the New York Court of Appeals in the court and date parenthetical superfluous, and you don't need to include it. Now, the Court of Appeals, and this is, Chantel, this is, New York is super, super, super quirky as far as the way it names its courts. So the Court of Appeals of New York is the highest court of last resort in the state of New York.
Right.
So, and if you'll remind me, if it would be helpful, if you'll remind me, I've got something from the Office of Court Administration in New York that gives a really quick and dirty breakdown of the court system. Because when you do your first year in a different state, sometimes coming into the New York stuff is kind of weird. So this is a state court decision, which means, and it's a state court decision from the court that you're citing to, which means you would include parallel citations. The state court citation goes first, then the regional, and then you omit the New York because you can already tell that it's New York Court of Appeals from the report or abbreviation.
Okay, I just have another question because the rule of thumb that I was given by a librarian was that in law school you never parallel cite. Like there's never any reason to. So if I was including this in my paper, in my document, would I parallel cite it anyway? That's what I'm...
One of our librarians told you that?
No. This is at another...
Okay. First of all, that's not true.
Okay.
What is true, and this may have been there may have just been a miscommunication, which is what I suspect, is that you don't parallel cite in scholarly works. So if you're writing an article about, this particular case, you wouldn't include a parallel cite here. You would only include the regional cite.
Okay.
But for practice documents, yes, you do parallel cite if it fits the rule. So for your document, assuming that the prompt tells you that you're writing to a New York State court or for a New York State court, then yes, you would parallel cite throughout.
But if I'm just, like this is the case that I used in that exercise 8.8 that we had to do for you.
Right.
That would not require a parallel citation because...
No, it wouldn't. That's a great question. It wouldn't, because there you're not... Yeah, there you're talking about it rather than citing it to a court.
Okay. And I just have one other question about the previous example that Andy provided.
Okay.
It was like Blake and Yahoo.
Right.
So, say for instance you wanted to, I guess, for whatever reason, to use Yahoo instead of Blake. Could you do that? Does the rule allow you to pick which person you want to list, or you have to put...
No.
First?
You list the first one.
You have to, okay.
Yep.
All right.
Yep.
Thank you.
Any other citation? I'm going to move on to statutes, but statutes, literally, it's going to take us about 3 minutes. Does anybody have any other case citations they're grappling with? Okay. Because you have the opportunity to do this now, I won't do it with you individually. Okay, just seeing, sometimes that stipulation to the offer changes people's minds. Okay, so now, statutes. With regard to statutory citation, for state citation, the rule is look at T1 for that state. That is your rule. Look at T1. I've never understood, I still don't understand why people get state citations wrong, because there's a formula for every state in T1. All you have to do is turn to your state. So, for example, of course, New York is going to be the one that you guys use the most. So if you turn to the New York section of T1, the court system is listed there. It starts with, first of all, the court website. Then it gives you Court of Appeals, all the different courts, all the way down. And then it goes to statutory compilations. And it tells you that you cite to one of the following sources if they're in. generally, the one that we cite to, our default, is McKinney. That's the first one listed. So if it's in McKinney's, you're going to cite it there, and it should always be in McKinney's. So New York, and then it tells you, you insert the subject, and then the word law, the section number, and the McKinney and the year. And then underneath that list of statutory compilations is the abbreviation for every single subject matter code in the state of New York. It goes on for 2.5 pages. And so there's no reason to ever guess at a New York State citation. It's all right there. So you just fill that in. You fill in that subject thing. You obviously get rid of the brackets around subject. You get rid of the brackets around year. And you just fill that in. And you do that for every state. And then for the United States, you look over to the federal section of T1. And again, you get through all of the courts. And then right before T1.2, you get to statutory compilations. And it tells you cite USC if it's there. Otherwise, you can do USCA or USCS. USC, so USC, it tells you, it's just the volume number, USC, the section number, and the year. Easy peasy. Okay? The only trick to statutes, okay, so first rule is T1. The second thing is you got to remember to tell your reader where you found it. And so in that date parenthetical, again, let's say we're looking at 42 USC section 1983, which is basic civil rights, the statute that governs basic civil rights violations. So let's say we're going to cite the current version. The current version was published in 2012. Okay, so that's the basic citation. If the section you're citing or the subsection is in the main volume. So let's say you're just citing subsection A. I'm making this up. I don't know how 1983 is divided. So let's say you're just citing subsection A, and that is in the main volume. So that's awesome. But let's say you cite subsection B, and subsection B is only in the pocket part or the supplement. In that case, whoops. You need to indicate the pocket part instead. So let's say it's actually in the 2014 pocket part. So we're going to indicate that parenthetically. Okay. So that's how you indicate that what you found was in the pocket part. I do not know why this wants me. Okay, there we go. Let's say that instead it was found, let's say you want to cite section C, and C1 is in the main volume, and C2 is in the pocket part. So you're going to indicate, whoops, you're going to indicate that it is in, that to get subsection C, you've got to look at both the pocket part and the main volume. So section 1983C, you'll cite the date of the main volume, ampersand, sup to 2014. And so that lets your reader know that to find subsection C, they're going to have to go both places. Because remember, we're not just telling the reader what it's called and what its authority is, but also where to go get it. And so we need to let the reader know exactly where to go get it. So those are that's the only thing that's a little bit tricky about statutory citation, is that you've got to do that. Okay, what if you want to skirt this entire issue and just go get it online? Okay, what if you don't want to go to the library, you don't want to look it up, you just want to do it online? That's perfectly fine, and you can do that, but you've got to cite it properly. Okay, so for statutory sites that you find online. We're going to look at Rule 12, which is the statutory rule. And we're going to look at 12.5 in the Blue Book 19th edition under electronic media and online sources. And it shows you how to cite those things as they appear when you find them online. And so,
where are we?
Pardon me? We're in Rule 12.5.
Thank you.
Electronic media and online sources. And we're under Part A, commercial electronic databases. So when we find this online, we cite it, whether it's state or federal, we cite it exactly the way it is in T1, except that in the parenthetical, instead of just the year, you indicate whatever the information is online that indicates its currentness. So, for example, this California Business and Professional Code, this is the first example, Section 1670. If you look in the California section of T1, you'll see that the parenthetical calls for the word Deering, which is the publisher, and the year of the hardbound volume. But here you're not using the hardbound volume, you're using a commercial database. So you're going to indicate what that says about the currentness. And here it said you're indicating the database that you use, Lexis, through the 1995 session. Why they use such old examples for electronic media, I will never ever know. And the real shame of it is they have one job, and that's to update this book every 3 to 5 years. And all of these examples are still the same in the 20th. They're literally 20-year-old electronic examples, which is goofy. Anyway, so that's how you cite it electronically. You just replace the year with the electronic information. You start with the name of the database and indicate what the currentness is on the database. Okay. Sometimes the currentness information will match some of these phrases. Sometimes it won't. Sometimes it'll say through the whatever special session. Sometimes it'll say through the it'll use different wording. Different legislatures use different wording. And so you just want to indicate what the currentness is according to Lexis or Westlaw or Bloomberg, whatever it is that you use. Okay. So that's statute. So that's basics. I just wanted to cover kind of quick and dirty on the basics of statutory citation and the basics of case citation. And so when you run across something that you don't know how to cite, just remember that for every citation, your reader needs to know what to call it, needs to know where to find it, and needs to know what weight to give it. So that's usually it's going to mean at least the year, and then for a case, it's going to mean the court also. And if you'll keep those things in mind, you'll usually be able, even if there's not an example that fits, you'll usually be able to craft it. And for those things that don't have reporter sites, that you find on Lexis or Westlaw, you can use the electronic citation rules for both cases and statutes. And they look much hairier than they are. They're really not that much different. And if you just follow along with the examples, you'll usually be fine. Any other citation questions?
Hi, Professor. I have a question. No.
Go ahead, Patrick. Why don't you go ahead, and then Shauna.
No, just for clarification, because my brief revolved on the ADA, and it's broken up in a title. Like it's not in. They don't call it sections; they call it titles. But would I just cite to the statute number instead of saying Title 1, Title 2, Title 3?
Yeah. I'm trying to think of how to approach this. Statutes are broken up a lot of different ways. There's titles, there's chapters, there's sections. And they don't all mean the same thing in every jurisdiction. In the in the federal system, title generally refers to a huge, like a huge section. So like Title 42 is generally, generally has to do with rights. And so 42 includes, pretty much everything from the Civil Rights Acts of 64 and 91 are in Title 42. So the ADA as a discriminatory prevention provision is part of Title 42. The ADA is broken up into sections, and sometimes acts like that will be broken up into chapters. So yeah, whatever it is that your statute or your provisions are broken into, use that nomenclature. So if the ADA is broken up into chapters, use, chapter whatever, section whatever. If it's just broken up into sections, you use section whatever. But the ADA is within a title. That's why it doesn't have titles that are part of it. Shauna, what was your question?
Hi, yes. I have the problem with registration and using the Copyright Act. And I'm just wondering, there are several sections that I'm using in the Copyright Act. I'm just wondering, am I supposed to, in the actual, in a paragraph, am I supposed to, or is it in the actual table of authorities where I'm supposed to put in main volume and then going through all the sections? I'm just wondering how I'm supposed to do that.
Yeah, you mean this information with the parenthetical?
Yeah.
Yeah, so that goes on the full citation, and that has to do with short forms. And so what I'll say about short forms is that, first of all the acceptable short forms are in both the blue pages and at the end of Rule 10 and the end of Rule 12. The end of Rule 10 for cases, the end of Rule 12 for statutes. The caution I'll give you is that you don't ever use supra or infra in practice documents. You can use id, but you don't use supra or infra. So after the first full time that you have cited something, after that you give short forms.
Yeah.
And you don't have to repeat it. So the date parenthetical is not part of a statutory short form. So for example, let's say I had all three of these sections in one paragraph, 1983 A, B, and C. The first time I cite 42 USC 1983 A, I need to give the full citation with the parenthetical and everything. Okay, so the next time I'm going to cite section B, I can do it as just section 1983B because it's still within 42. And so I can just do a short form. And because this is different than the long form that I gave already, I would need to include this information because the reader wouldn't know for section B to look in the supplement unless I tell the reader.
I'm sorry.
When I get to section C, I can again cite it, just 1983 section C, but then I'd need to also give this information, okay? Now, let's say my very next citation is to 1983B again. I don't need to give this parenthetical information the second time. I only need to give it the first time. So if my next citation is to section 1983B, this is an acceptable short form. Okay, does that answer your question?
A little bit. I guess my question is, in my first, I think in my first paragraph of my argument section, I actually list the different sections of the Copyright Act that I'm going to be using.
Okay.
And I don't have them in long form citation. I don't have the full citation. So I'm assuming, because I'm listing to the reader what is going to be used, I'm going to talk about in a document. I'm assuming that I need to list this out all in full citation.
That's what I'm saying. That's what I'm saying.
Okay, yeah.
I've got several. What I'm telling you is, if there are parts of it that are repeated, like you've got subsections within a main section as we do here, you don't have to repeat the full citation every single time. You only have to repeat the parts that are different. So if it's 1983A in the long form, when I cite 1983B, I can just do this much of it. So I don't have to repeat the full thing. However, if I move to a different title, or if it's a different enough section that the reader might not know it's within the same grouping, then you may want to repeat the title number again. Okay. So yeah. Okay. Does that make sense?
Yes.
Okay.
I think I just need to change the stuff around.
Okay. Yeah. Any other questions about citation? Okay. Excellent. Okay, I hope this has been helpful to you guys. If you think of questions I didn't address, feel free to email them to me, and I can address them on Tuesday. Tuesday, we're going to start with the visual persuasion stuff. I may shave a little bit of that off so that we don't go too long. And then we'll go a little bit extra on Tuesday night, getting into the literary illusion and borrowed eloquence stuff. Okay, thanks for coming. I'll see you guys Tuesday night. And Andy, I'll stick around about that one citation.
Yeah, Professor Norton, do you want me to stick around as well? To talk about what I emailed you about, or?
I'll tell you what. Why don't you? Then yeah, you can stick around for that. That's fine.
Okay.
Okay.
Andy, you can go first.
Okay. So Andy, I'm copying this.
I emailed you the actual case, and if you look at the site, that number in the site where it says at 846 is exactly where that case quotes.
Oh, I think I know what you're talking about. Hold on, let me pull it up. I think you're having a star paging issue.
Yeah.
That's not a line number.
Right, it's a pin site, right?
It's a pin site to a different... Okay, so... Hold on. Okay. So I've got the case up right now. Okay, at the very top of the screen, I know it's hard to see because this is very tiny. At the top of the screen are the parallel sites. 519 U.S. 337, 117 Supreme Court 843. 847 is a reference to the Supreme Court reporter version of this.
Correct.
Right. But you're not citing Supreme Court reporter, you're citing U.S. Let me show you.
Okay, because this was actually, I don't know what I did.
Okay, so look, in the syllabus of the opinion that I've got up here on the screen, in the third paragraph, the beginning of this paragraph starts star 338.
Right.
That means everything after that's on page 338 of the U.S. reports version. In the same line, you see double star 845. Everything after that is on page 845 of the Supreme Court reporter version.
So my pin site should actually be 338.
There you go.
Okay.
So as you go through, to figure out where your information is, you're looking for the single asterisk numbers.
Because initially when we went through and we did the brief, we did full sites, parallel, we did the whole citation?
You don't ever parallel cite to the United States Supreme Court.
I'm trying to think. I'm trying to find one of my full citations from like the very beginning of it.
Yeah. So it looks like I've got it right now where page 847 is in the Supreme Court reporter version. And so it looks like your information is either on 342 or 343 of the U.S. Reports version.
The initial, that was the short cite for it, and the initial full cite, hang on 1 second.
But Andy, that's not even a proper short form for a parallel cite.
Okay, because the initial, I just put the initial one in the comments.
Okay, let me look.
So it has that 519.
Okay, so let me, hold on. Okay, so the first thing is that I want to be super clear on is you don't ever parallel cite Supreme Court cases. The Blue Book says don't do it. That being said, if the person you're writing it for wants parallel cites, give them parallel cites. Whoever's assigning the grade or writing the checks can tell you what to do. Second thing is, Supreme Court should have a space between it because court's a longer abbreviation.
Right.
U.S. should be United States. You don't abbreviate U.S. under the Blue Book. It's always spelled out. Okay, so let's assume that this was a proper cite and you wanted to pin cite it later. Okay? So, okay, the other issue with this is you have a pin cite on one reporter but not on the other one.
Right.
And so if you're going to pin cite, you've got to pin cite both of them.
Okay.
And so, in fact, I don't think that's where that case started. No, it is 337. So 846 is going to be.
I have it in the Supreme Court part, but not in the
right. So it's
US report.
It's going to be 341. It looks like, or 342 is going to be your pin cite there. So if you were going to do a pin cite, it would need to be. Wait, hold on.
On both.
Right.
My next question for you is because.
Well, wait. Let me show you this real fast. Okay. So if you were going to give a short cite with a pinpoint, it would be Robinson 519 U.S. at 341 17 Supreme Court at 846. So that would be your short cite.
Okay. Now, because the professor that I wrote it for wanted it this way, the way that I have it in my paper, do you want me to go back and change it all because you wanted a different way? I mean, I'll make the corrections we're talking about.
I want it according to the Blue Book, and this isn't according to the Blue Book.
Okay, so I'll go back and I'll review all the cites according to the Blue Book. And I just had one other quick question for you.
You bet.
Typically, how many footnotes do people put in their paper? Because I'm gonna get kind of up there.
I wouldn't.
I don't know if you have like a limit that you don't want me to go over, or because I have a lot of corrections to make.
Nope. It's gonna depend completely. I mean, it's gonna vary. It's gonna vary a lot from student to student.
And can I put on my table of authorities, I put a footnote that I corrected all the citations. Is that good enough for even the ones that are in the body of the paper, or you want me to cite those as well? Footnote those as well, I mean.
No. If you've if you've corrected them all, that's fine. Just,
okay, because I just put one footnote.
Yeah.
That I corrected them all.
Yeah.
Okay.
Yeah.
And don't parallel cite U.S.
Yeah.
Gotcha.
Yeah.
Thank you.
You're very welcome.
Have a good one.
Okay, thanks. I'll see you. Okay, Chantel, hold on just a second and let me... Okay. Hold on. I want to stop recording on both of these.